Today we are talking about the way that employment lawyers prove retaliation, and we're starting right now. Thank you for tuning into my channel. My name is Brandon Ortiz. I'm an employment attorney here in sunny Burbank, California. I'm the owner of Ortiz Law Office, and I've created this channel to give helpful tips and advice to people out there who are having trouble on the job and have some questions and need some help on what to do. Before we talk about how you prove retaliation, we need to define what retaliation is. Most people are aware that in California and in the other states, you have what is called at-will employment. What at-will employment means is that you can be terminated at will. You can also quit at will. Now, an important corollary of at-will employment is that the employer can change the terms and conditions of employment at any time for any reason. So, employer one day gets up out of the wrong side of the bed and decides he wants to cut your pay, he can do that. And if you don't like it, you can quit. Now, over the years, the law has realized that, well, one, that's pretty harsh, but two, that can create some really sticky predicaments. And it can, that kind of power can encourage employers to use it for nefarious means that undermine the law. And one of the more famous cases of unlawful termination was a case where a labor union business agent refused to commit perjury, and he was terminated, and he sued for wrongful termination. And so over time, the courts have developed exceptions to the rule of at-will employment. And generally speaking, and these are all creatures of both judge-made law, case law, and statute. Laws that Congress write, laws that the California legislature write. And two of the bigger exceptions, generally speaking, are when you report something that's illegal. Let's say you report that a colleague's being sexually harassed. That would be protected under the law. Or if you report that you yourself are being sexually harassed, that would be protected under the law. Or let's say your employer is dumping toxic sludge into the river, and you report that to the Environmental Protection Agency. Under the law, that would be protected because you're reporting to a governmental agency a violation of the law. And if the employer fires you because of that, then they are liable for all the harms and damages that they caused. But that is the key. You have to prove that the termination was because of, or to use the legal jargon that we use in our business, that the protected activity substantially motivated the termination. And under some laws, the standard's even lower. You just have to prove that the protected activity was a contributing factor in the termination. So when we talk today about retaliation, what we're talking about is proving that the complaint was a contributing factor or substantial motivating reason for the termination or the demotion or the pay cut or whatever form the retaliation takes. I get phone calls from prospective clients all the time who think that they are the victim of retaliation. They complained about something that was happening, 2 weeks later, they're fired. Or they're asked to do something illegal. They say, no, hey, wait a second, I can't do that, that's illegal. And then, a week later, 2 weeks later, they're fired. And they come to me and they want help, but they don't think they can prove that it was retaliation because after all, they didn't come out and say that, hey, we're firing you because you complained. They didn't come out and say, hey, we're firing you because you're refusing to do something illegal. And they talk to me and they don't think they can prove it. And so what I want to talk to you today is the way that employment lawyers prove retaliation. And it really is not rocket science. A lot of this is just good old-fashioned common sense. And it's been recognized in cases that have been published over the years that these are recognized ways of proving that somebody is the victim of retaliation. Now, the first and the most obvious is what the law calls direct evidence. Direct evidence is statements from the employer that don't require, a logical step in between. So if they come out and say, I am firing you because you complained about sexual harassment, I am firing you because you are refusing to engage in price fixing, that would be direct evidence. As you can imagine, most employers are smart enough not to come out and say that they're doing something illegal or firing somebody because they reported something. Although every now and then, sometimes they actually will, but that's pretty rare. Typically, we have to rely on what the law calls indirect evidence. Okay, and indirect evidence is it's circumstantial evidence. Okay, so number 6 is when the reason for the termination is implausible or unworthy of credence. Okay, this is when they give a reason that on its face, you're just scratching your head and you're like, what are you talking about? That doesn't make sense. For example, let's say that you are a cake designer and you win an award for the best cake in town. And the employer fires you because they think your cake design that just won best cake in town was ugly and didn't look good. Well, if that happens right after protected activity, you can argue that they're just using that as a pretext. And the real reason is the most obvious reason, which is that you complained because everybody thinks this cake is beautiful. A jury can deduce that that reason is not rational. Number 5 is a sham investigation. Very frequently in employment cases, the employee who engaged in protected activity is subjected to a false accusation. Supervisor accuses the employee of stealing or accuses the employee of harassing somebody else or some sort of workplace incident. And the employer comes in and basically just does a paper investigation. That's not a real investigation. They already have a preordained result in mind. That is a way to prove retaliation. And it's actually one of my favorite ways to prove retaliation because it's sort of amazing at how bad employers are at responding to scrutiny of their investigation. But the inference that you can draw from the sham investigation is really simple. An employer that is trying to do the right thing, an employer that is acting above board and honest, wants to know the truth, right? If you're an honest businessman or businesswoman and you see that one of your employees has been accused of something, you would want to go and at least get that employee's side of the story, right? If the employee is saying, hey, there's 3 other witnesses here, they'll all say that I'm innocent of this. A rational, honest employer is going to go and talk to those people and see if they corroborate the employee. What I see all the time in these whistleblower retaliation cases is that the plaintiff, the employee, gets fired and they don't even go and talk to the employee to get his side of the story. Or the employee will say, hey, go look at this email. This email will confirm this or that. Or go talk to this witness. This witness will confirm this or that. And then they don't. And, those are always pretty powerful evidence of retaliation. Okay, so number 4 is when the employer changes its story. And this is shockingly common in employment litigation cases. They'll give one reason for the employee when they're terminating them. When they get sued and they lawyer up, they'll give a different answer when they have to give written responses to questions. And then when you go and you depose them, which is basically live questioning under oath, they'll tell a different story. And then when you go and you question them at trial, they'll tell another story. And this is amazingly common in wrongful termination cases. And, if you think about it, it's not that surprising, right? Because when you're lying and you're not telling the truth, it's hard to keep your story straight. And it's especially hard to keep your story straight when you are an organization with lots of different people working in it. Very often, you'll have multiple people involved in a termination. And it's very common for, Supervisor A to tell a different story about why the employee was terminated, and Supervisor B tells something that's diametrically opposite of that. That's extremely common. It's actually extremely common in a lot of these cases for the employer to be unable to agree who actually made the termination decision. One person will sign the termination letter, but then when you go and you question them, they say, oh, no, I was just signing the letter. I didn't actually make the decision. Joey made the decision. And then you go and you depose Joey, and Joey says, no, it was Jane. Jane made the decision. Then you you depose Jane, and Jane points it back to the first supervisor. And, that's extremely common in cases where there's something illegally done and nobody wants to take the blame for making that decision. Okay, so the number 3 most common way to prove retaliation is through evidence of the employee's prior performance. And I alluded to this a little bit earlier, and you'll see that there's a lot of overlap between all these methods. But when an employee has a track record of being a good employee prior to the protected activity, then all of a sudden, after protected activity, the employer's perspective of the performance of the employee changes. That's a pretty big red flag of retaliation. And in law school, I took an employment law class, and it was a running joke in this class that a week or a month after the employee gets a big award, they get terminated. And I've had cases like that myself where the client gets like a big corporate chain-wide award, and then a month later, is terminated. And, that's usually a sign of a strong case because good employees, like I said earlier, they just don't deteriorate overnight like that. So the number 2 most common way of proving retaliation is by proving that the reason given for the termination is false. And, example of that would be that, employee shows up 30 minutes late to work, according to the employer, but we can actually prove that not only was the employee not late, the employee was early. Or the employee is accused of assaulting somebody, but every witness in the room says, no, he did not assault somebody. In fact, he was the victim. False reasons is a very common thing that comes up in wrongful termination and retaliation cases. And courts have explained that if the employer provides a false reason, the jury can infer that the employer is disassembling, meaning that the employer is lying, that the employer is making something up. And once that reason has been ruled out and eliminated as not true, the jury can then infer that the more likely reason is because of the protected activity. One way of proving retaliation is timing. Timing. An employee has a track record of great performance, engages in protected activity, and then the next day gets terminated. And the reason is you're a bad performer. The fact that this happens right after the protected activity and the fact that you have this long track record of good performance prior to that, that's pretty powerful evidence of retaliation. And the timing can cut both ways, and it can save defendants. It can save employers in some cases. For example, if the employee's getting written up and is getting bad reviews long before they ever engage in protected activity, most employment lawyers who represent employees, they're going to stay away from that case. Those are tough cases because the timing favors the employer in that case, because the employer was not happy with the employee's performance long before the protected activity. If you liked what you saw today, please be sure to click like, click subscribe down below. If you're having problems at work or you were just recently terminated and you need legal advice, don't hesitate to give me a call, 888-37-ORTIZ, 888-37-ORTIZ, O-R-T-I-Z. The number is down below, and my website is also down below, ortizlawca.com. Stay safe.